You're listening to Boomers Today with your host, Frank Sampson.
Well, welcome to Boomers Today. I was about to say Aging Boomers. That was the name of our show, but it's now called Boomers Today. And I want to thank everybody for joining us. I'm Frank Sampson. And of course, each week we bring you important, useful information on issues facing baby boomers, their parents, and other loved ones. And of course, we have another great show, and the reason we have great shows is we have great guests. And our guest today is Mitchell Kitroser, who is the founding managing attorney of Kitroser. Did I pronounce that right? I don't want to botch the name, Mitchell. It's Kitroser, is that right?
That works fine. Thank you, Frank.
Okay, so it's Kitroser and Associates, a South Florida law firm focusing on elder law, estate and trust administration and litigation, guardianship, and Medicaid planning. He is AV rated by Martindale Hubbell, the highest possible rating for an attorney. So, Mitchell, I want to thank you so much for joining us on Boomers Today.
It's my pleasure to be on your show.
Yeah, so there's so much to talk about as it relates to elder law and a lot of different subject matters, so we're going to try to get going here. But just a general question, because I think it would be quite interesting for people to understand more about elder law and what an elder law attorney does. And an elder law attorney does a lot of things. I'm aware of that. But maybe you could give just a kind of an overall explanation or definition of elder law and what you do day to day.
Sure, I'm happy to do that. And different elder law attorneys will do different things. So for your listeners, if they feel like they want to talk to an elder law attorney and they look in, let's say, Google for elder law attorneys, they might find attorneys that focus primarily upon Medicaid planning, getting people disability benefits, special needs planning for children with special needs. They might find an attorney with a broader practice, more like mine, where we also, in addition to doing those things, we focus our practice on guardianship and estate planning and asset protection for seniors, and long-term planning for children with special needs. And it will depend. Elder law is a pretty broad term, and different lawyers define it differently, and different practices narrow it in different ways. But for the most part, when you're looking at an elder law firm, you're looking at a firm that addresses their clients' needs through the lens of dealing with people who maybe need a little extra protection, a little extra care, people who are not always fully cognizant and may need some help with protection.
Got it. So, when you mention estate planning, I'm sure everybody listening to this has heard that term. But what does that mean, estate planning? Give us some examples of that.
Well, we all think that we need a will, and people come to my office all the time and they tell me, I need a will, I want to redo my will. What I very rarely hear is, I want to redo my power of attorney, or I want you to look at my healthcare surrogate document. And ironically, to me, those two documents are far more important than a will, because all a will does is tell the court who to give your stuff to after you're dead. A power of attorney is a document that's going to protect you if you get sick or hurt and can't manage your own financial affairs for a while. And a healthcare surrogate document is going to be the document that appoints somebody to make a medical decision for you in an emergency. If you get in a car accident or you have a sudden illness and you're unconscious in a hospital, and it's not that you're going to die, but somebody's got to step in and authorize surgery or transfer you to a different medical facility. That's what a healthcare surrogate is going to do. So when it comes to doing estate planning, a full package of estate planning documents should include not only a will, but a durable power of attorney, a healthcare surrogate document, a HIPAA waiver to authorize somebody to speak to your doctors if they need to, probably a living will, maybe a revocable trust if you want to do a more sophisticated version of an estate plan. Possibly, depending upon your age and your health condition, do not resuscitate might be included in the documents. And then a good estate planning attorney is also going to sit down and look at your tax issues, although not that many clients these days have tax issues because the threshold for state taxes is so high. But in addition to that, other types of trusts depending upon your needs. If you have children with special needs, you might be looking at some special needs trust planning, irrevocable trusts. If you have beneficiaries that you're looking at who maybe are spendthrifts who are not responsible with money, you might be doing a spendthrift trust for them. And then if what the client's coming in to talk about is Medicaid planning, and you have to manipulate assets to get a loved one qualified for Medicaid, and they're married, then their spouse's estate plan needs to be completely retooled because we don't know as lawyers who's going to die when. And if the spouse who is fine today dies before their spouse who's living in a nursing home and on Medicaid, then all of those assets then become at risk if the spouse in the nursing home gets them. They're going to lose their Medicaid benefits. So estate planning is a fairly broad topic, and for an elder law attorney at least, we're looking at it through that lens. We're looking at it through the lens of what are the needs of this particular family as they come in. I think that's probably true for any estate planning attorney, even if their focus is not elder law.
All right, so I have a couple follow-up questions for you on that. So you mentioned power of attorney, which, I'm glad you mentioned that, and durable power of attorney. So if you could, in all due respect to your profession, I think it's a lousy name. And the only reason I think it's a lousy name is I think when people hear power of attorney, they think, oh, my God, this is going to cost me a fortune, and do I really need to do this, and do I really, So why don't you explain exactly what a power of attorney is, the difference between that and a durable power of attorney? And I always tell people, and I'm not an attorney, all right, but I tell people, you're 18 years or older, you should have a power of attorney. I'm not sure if you agree with that, but can you talk a little bit more about it and why it's so important? And I'm glad you said it's probably even more important than the will, and I agree with you on that. But why don't you expound upon that?
Sure, and I absolutely agree with you that anybody who's over the age of 18 needs to have a power of attorney. In fact, what we tell our clients is when your children turn 18, before you send them off to college, before you let them out the door and live in another city or another town, have them come into our office and we will do a power of attorney for them along with a healthcare surrogate and a HIPAA waiver. So if your kid gets hurt while they're at school or sick while they're at school, you are not shut out of information. Parents don't realize that once their children are 18, their rights under federal law, under HIPAA, kick in. And even a parent can't find out what's going on with their kid away at school unless they have these waivers and these documents. So very, very important to do them. In fact, for our clients, we offer them free of charge. That's just a service that we do, because I think it's so important.
And if I may add one thing, that's the same with a spouse. Just because you're married, you still have to have power of attorney.
Absolutely.
Right.
Certainly, even with a spouse, it's important. Healthcare is a little different with a spouse, particularly I'm in Florida, and a spouse will be able to make medical decisions in Florida without a healthcare surrogate document or a healthcare power of attorney. But still, it's so much easier, and you're talking about documents that are really designed to help in an emergency. The last thing you need in an emergency is to have to argue with somebody over whether you have legal authority. It's so much easier and better to just get stuff done in advance. Right. To answer your question about the word durable, so when we talk about powers of attorney, there's really a couple of different flavors. The durable general power of attorney, which is the overarching power of attorney, is the document that gives somebody else the authority to do for you pretty much everything you can do for yourself from a financial point of view. So, for example, if I have power of attorney for you, I can sell your car, I can sell your house, I can do your banking, I can pay your bills. I can bring a lawsuit on your behalf if you're hit in an intersection and you're in a hospital and you're not capable of making these decisions. I can retain counsel for you. I can deal with the IRS if you have tax issues, and a whole variety of other things. I can deal with your insurance. I can deal with your retirement benefits. That's what a durable power of attorney can do for you. And the word durable simply means that it survives your incapacity. So if you were to become incapacitated, this power of attorney is still effective. That's what the word durable comes into play on. There are also limited powers of attorney, and some of your listeners may have used those. For example, if somebody is selling a piece of real estate but going out of town, going away on vacation or taking a medical trip or something, and won't be there for the closing, they can do a limited power of attorney for a specific purpose, such as signing the closing documents. So 2 different types of powers of attorney.
So somebody, and again, I've dealt with this with families, but maybe you could, again, make some comments on this. But some families wait too long. They have a parent, let's say, who is needing care. There's no power of attorney. And they get to the point, maybe with dementia or some form of dementia like Alzheimer's, and they go, well, boy, we have to get we better do the power of attorney. It could be too late at that point. Am I correct?
You are correct. No responsible attorney is ever going to let somebody who doesn't have capacity to understand the documents sign a legal document. And that becomes really important as people get older, because one of the powers that you want to put in a power of attorney, and again, when I say that lawyers look at things through their own lens, an elder law attorney's power of attorney might look a little different from an attorney that doesn't do elder law, because an elder law's attorney's power of attorney is going to include somewhere in there the right to do Medicaid planning, the power and the authority to gift assets and move them around in order to qualify a loved one for Medicaid. And these are pretty powerful powers. These are things that you don't want to give away. You don't want to see a client give away if they don't really understand what they're doing, because in essence they're authorizing somebody to take the assets that they've worked hard for and they've saved their entire life for and put them someplace where they can no longer claim ownership over them.
Right.
So no attorney is going to do that unless they're comfortable that the client they're sitting across the table from understands exactly what they're doing.
That was a great lead-in to my next follow-up on Medicaid planning. There's people get confused with Medicare and Medicaid. Medicare being more, I guess, health care insurance for people that have earned it, of course, 65 and over in the United States. And then Medicaid, I guess we could spend a whole time just talking about what that is, but I try to explain it as more, it's almost like long-term care insurance for seniors, or it can be, but it meant many times it's only in healthcare locations like nursing, etc. But the perception out there is that you pretty much almost have to be out of money in order to get approved with Medicaid, and that's true. But when you talk about Medicaid planning, if somebody does have too much money to get approved, there are legal ways from an estate planning standpoint to set up the estate through trusts, etc., that you can get approved. Talk about that a little bit so people understand. I know that's a loaded question. You could probably talk for an hour on it, but let's I'll let you give an overview of it.
Okay, well, there's three subtopics there. The first is that Medicaid, you're right, is a needs-based program, and again, we call things by similar names, but they have nothing really to do with each other. Medicaid is a needs-based program, so what the government does is it says if you're poor, and by poor I mean really poor, and you need health care services, Medicaid will be available to help you. But what your listeners need to know is that each state, although it's a federal program, it's administered state by state on a state-by-state basis. And one of the terms people have probably heard over the years is Medicaid expansion. And that's critical because some states have adopted Medicaid expansion as part of the Affordable Care Act, and other states have not. And, for example, Florida has not, and therefore our Medicaid benefits are fairly limited. A lot of the other states around the country have, and they have more expansive Medicaid benefits. So for anybody who's thinking about Medicaid, you've really got to consult with an attorney in your state who is familiar with the Medicaid rules. I'm going to give you a plug for NAELA at this point. NAELA is N-A-E-L-A, and it's NAELA.org, which is a national website. It's the National Association of Elder Law Attorneys, and most good elder law attorneys are members of NAELA. It provides us with resources and educational services and the like. If you're looking for a Medicaid or an elder law attorney, that would be one place to stop and take a look, and you'd be able to locate attorneys who are local to you. When it comes to looking at Medicaid benefits, you really want to get with an attorney in your area, in your state, who's familiar with that, because those are the people who are going to know what's going on. So to do the planning part of it, there's really two types of planning that I see. There's the clients that come in and say, I know that at some point down the road I may have dementia. What do I do? We don't see too many of those, because what happens in those situations is I'm typically telling them that they have to start to move assets out of their control, and nobody really wants to do that when they're fine. The more common situation that I get is my spouse has just fallen and broken a hip or has dementia, and I can't take care of them at home anymore. They need to go into a nursing home. I haven't done any kind of planning. Do I need to spend down my assets in order to get them qualified for Medicaid so that we don't go broke paying for the nursing home? And the answer to that is no. In both of those cases, the answer to that is no. You can plan in advance. Your listeners have probably heard of the phrase the look-back period. Right. Well, the look-back period used to be 3 years, and what the look-back period means is simply you can't give away your assets within a period of time and then qualify for Medicaid. So, for an example, mom has $1 million, needs nursing home care, has dementia, daughter has power of attorney, went to an elder law attorney, so has a power of attorney that gives her the right to give away mom's assets, even to gift them to herself. And daughter takes mom's $1 million and gifts it to herself, and then applies for Medicaid and says, see, mom is poor, she has no assets. Well, obviously that's not going to work. That's going to trigger a violation of the look-back period. But had we done that 5 years before mom needed nursing home care, it would be fine. That's the 5-year look-back period, and that's how that works. More often, though, what I see is that people come in at the last minute and they say, well, what do I do now? Mom has fallen. She needs nursing home care. She has $1 million. Do I need to spend all of that money down before I qualify her for Medicaid? And the answer still is no. There are techniques that can be used, depending upon what state mom lives in, that can preserve some or all of those assets and use them still for mom's benefit, but allow her still to receive Medicaid benefits somewhere along the way so that she doesn't exhaust all of her money. Because what happens is when you're on Medicaid, you only get a certain amount of money each month. The rest of it goes to the nursing home. The taxpayers make up the difference. And Medicaid only pays for the facility. It only pays for a semi-private room, the care, and the food. Anything else that mom might need, new clothes, eyeglasses, maybe a cell phone. Perhaps she wants to take a trip to go see a grandchild get married or a great-grandchild have a baby naming. None of that stuff is ever going to be paid for by Medicaid. So if you can take some of mom's money and sequester it in a place where it will not disqualify her for Medicaid benefits and use it to enhance her life for the rest of her life, I consider that a good thing. Now, ultimately, the state's going to get repaid for everything that they spent for mom during her lifetime. But still, Medicaid planning helps to enhance a client's lifetime. Right. And to enhance the quality of their life, even when they're in a nursing home.
You did a great job in explaining a very complicated subject matter, so thank you for that. And, I do want to talk to you more about protecting seniors against exploitation, which is a big problem. But before we do, I just want to remind everybody that today's show is sponsored by Senior Care Authority, a senior placement and elder care consulting organization that has a national network of professionally trained and experienced local advisors to assist families in determining the right place for your loved ones. They'll discuss various long-term care options, whether it's in-home care, assisted living, memory care, nursing care, or if you just need an advocate to get advice from, a local Senior Care Authority advisor can help you now. For a free 30-minute consultation with an advisor in your area, contact Senior Care Authority at 888-809-1010. 1231, or you could go directly to the website at www.seniorcareauthority.com, and you can find an advisor in your area. So with that, Mitchell, let's talk about, which is just a horrible problem everywhere, and that's seniors being taken advantage of. Sometimes we refer to it as, abuse. There's physical abuse. Sometimes when people hear abuse, they think of physical abuse, but it could be financial abuse, just taking advantage. You've referred to it, which I think is a great term, is just exploitation. Talk to us just how big of a problem this is, and what's being done, and any advice that you can give to our listeners to help protect seniors against it.
Exploitation, at least from my practice, is an enormous problem. We see a lot of it. We see it in our guardianship practice, and it typically takes one of 3 or 4 different versions, and the patterns repeat themselves time after time. There's the stranger who comes into somebody's life and befriends an older person. Maybe they're lonely, maybe they're vulnerable, maybe they've lost a spouse years ago, and their kids live elsewhere, and suddenly this person is paying their bills and then says, well, it would be so much easier if I just had power of attorney so that I would have easier access to your accounts, and money is disappearing. Unfortunately, there are other forms as well that we see a lot of. One is children. Children come in, and occasionally you see a family where there's one child who just remained financially dependent on parents through their lifetime. And when a parent is fine and they want to help their kid out, nobody really has a problem with that. But when the line starts to get crossed and the parent starts to become less cognitively aware and less able to make their own decisions and more vulnerable to what we call undue influence. That's a word we lawyers use for it. That's the point at which it's no longer okay, and we see a lot of that where children are just pushing parents. Hey, mom. Hey, dad. You've always helped me. I need another $100,000. And of course, then the other children find out, and there's a family war. Another situation, another scenario we see a lot of is a second spouse in children by first marriage. Even if you went out and you got yourself a prenuptial agreement when you got married the second time or the third time, a prenup only protects you if you maintain your assets in a separate account. And what we typically see in these situations is that the second spouse works on the spouse and starts to encourage them to move assets from their separate account into a joint account or into the spouse's account, and little by little money starts to move from one spouse to the other spouse. And again, the children find out, and there's a whole war. So planning would be a really good thing. The problem is that when I do planning for people to prevent exploitation, the person that I have to protect my client against is themselves. And that's very hard to do. Nobody, at least nobody who's walked into my office, is really all that comfortable with the idea of taking their assets and turning control of them over to somebody else. But unless you do that, unless you're prepared to do that, you're vulnerable later on in life. Take for example, this 75-year-old man who's lost his wife, and he's home, and maybe he did well in life, and he's got $7-8 million to his name, and he comes in my office and my wife, I need new estate planning documents. We'll have a chat, and one of the things we're going to talk about is that he's going to receive briskets and roast chickens and pot roast. And it's a fairly common thing. He's a successful single man in his 70s. He's vital. He drives at night, all the things that make you desirable in South Florida. And now he's going to meet new women, and maybe he's not interested, but he's going to. It's going to happen. And at some point, he's going to come up from underwater and be more aware of the fact that he still has a life to live, and he's going to want to be social. And under those circumstances, maybe he'll meet somebody, and he'll want to spend time with this new companion. But he still wants to leave the fruits of his labor, the fruits of his work, to his children when he passes away. And this is the point at which he becomes vulnerable. And at 72, 73, 75, he's probably okay. But when he gets to be 85, particularly as cognition declines, and if he's one of those people, as many of us are, he's going to be more vulnerable. He's going to be more susceptible to exploitation. So he would be somebody who would need a plan. And he may not like the plan I'm going to propose, but I'm going to propose to him that he take the majority of his assets, if he's worth $7 million, maybe 6 of it, and place it in an irrevocable trust with a professional trustee to manage his assets for him. The professional trustee can pay him income, and the professional trustee can also dispense principal to him as he needs it. He'll still have his own account. He'll still have the ability to do what he wants with the money that he keeps in his own account. But the rest of the money won't be vulnerable to exploitation. Nobody will be able to take it from him. Not his new companion, not a stranger, not even his children. All of whom are potential exploiters in any scenario. And it's a hard discussion to have with a client, and it's a hard thing for a client to do because they don't want to give up control. But you can see where that's where the vulnerability is. This is a person who will be vulnerable at some point in their lives. And those are the folks that I end up doing guardianship cases on. And guardianship gets to be expensive and time-consuming and heartbreaking. So to the extent that we can protect somebody's assets, we can also protect them from exploitation. If we're protecting them from exploitation, we're probably keeping them out of guardianship court.
Those are tough situations to deal with, I'm sure. But thanks for discussing that. Boy, I could talk to you for quite a bit longer, but we're kind of getting out of time here. But if you could take the time to let everybody know how they could get a hold of you, either a website, number, whatever you want to share. And also, if you wouldn't mind mentioning NALA again, in case I know you're in Florida, but if somebody's in another part of the country and is looking for an elder law attorney, maybe you could bring up that website again. So
sure.
Go ahead and share your information.
So the website to go to is naela.org, naela.org, and that's anywhere in the country. And then once you're on the site, you can give your location, and it will provide you with local elder law attorneys close to you. If you're in South Florida and you're looking for an elder law attorney, there's several of us down here, a lot of us who are very, very good. My name is Mitchell Kitroser, and my website is www.kitroserlaw.com. And I'm fortunate in that my name is fairly unique. So if you were to type in Google Mitchell Kitroser, I think I'm the only one you're going to get.
I think I may have botched it. So Mitchell Kitroser, kitroser.com. It's kitroserlaw.com, I should say. So,
yes.
Mitchell, thank you so much for joining us on the Aging Boomers, and thank you everybody for joining in. And just be safe out there, and we'll talk to you all soon.
Thank you, Frank. Have a good day.
Thank you.
You've been listening to Boomers Today with Frank Sampson. To learn more about today's show, visit boomerstodayradio.com and join us next time for another edition of Boomers Today.